Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a number of books published by Wildy, Simmonds and Hill Publishing. They're part of the Wildy's Legal Handbook series. I've reviewed a number of the books. There are 3 in the series. There's a sort of red title, a blue title and a green title, if I can put it that way. But I'm looking today at the one which Khawar Qureshi QC has published with the assistance of Catriona Nicol. This book is entitled Conflicts of Interest in International Arbitration, an Overview. Elizabeth and I talked about the book, and we've given for our review title, which is in the journals and on the web, the following title: A Restatement on the Overriding Importance of the Arbitration Process for 21st Century International Practitioners. And that's what we've got, because we are facing a very strange new era that's coming upon us with withdrawal from the EU, and the way that we're going to be looking possibly at international law in the future. And I think this book adds very much to the sum of human knowledge in this area, especially for practitioners in England and Wales. Now, this is the book itself. There's the front cover. This is the red one. There's the spine, and then on the back you can see there's the author. There we go. And you can see basically the standard information on the back. There's no index. The book runs to about 185 pages. That's the last page. This is some basic information. This is Annex 2 that I'm looking at the moment, which is giving, when I get to it, Annex 2, Decisions on Changes to Arbitrators, 2005 to 15. So there's quite a lot of information at the back. The front of the book, there is the title page, and you can see the previous titles in the series. That is Public International Law Before the English Courts and Bilateral Investment Treaty Claims, the Essentials. And then there's some information about Wildy's there, and then you've got the contents section. It's not numbered, chapters are not numbered, but it does look very much at the international rules. Then you've got 2 appendices or annexes. The first is on legislative provisions, and then the others are decisions on challenges to arbitrators. Very useful foreword has been produced, which is at the front, and it's been written by Sir Bernard Ricks, and I'll refer back to him in a minute. That's dated February 2016. Then there's an introduction looking very much at international arbitration. It says international arbitration is increasing in prominence as a method of resolving disputes. That's certainly been the case. It probably will continue to be the case because of the costs, of course, of going to law and the main courts. There is some footnoting. There's no paragraph number or anything like that, but there is footnoting. And you've got, obviously, a lot of rules which are referred to. This man, Mr. Qureshi QC, Khawar Qureshi, is a very, very experienced commentator in this area. He's a Deputy High Court Judge, and I believe he's offering us a tremendous amount of his knowledge and expertise in these 3 books. When I'm very grateful that Wildy's have taken the books under their wing. So what do we say about this book then? Well, we say this. It's another excellent short title. It's a paperback by Khawar Qureshi QC in the Wildy's Legal Handbook series. It's called Conflicts of Interest in International Arbitration, and is an overview of this, what is a specialist legal area aimed at arbitrators and barristers who need, quote, to identify and unravel the different institutional rules that may apply in any matter which they are instructed upon. And that's really the basis of the book. More emphasis today, of course, is placed on international arbitration, and it is increasingly prominent as a method of resolving disputes because of the way we do our legal business, with the changes that have been introduced, certainly by digitisation and all the other things that are taking place at the moment as we enter a new 4th industrial revolution with digitisation, artificial intelligence, and very online courts, for instance, very wide range of changes that are going to take place probably within the next 5 years. Certainly during my time as a practicing barrister, I have seen a large change, and this is the next phase, probably as we go into the mid-2020s. Now, as the author says, the arbitration process has to reflect core elements of the judicial process if it's to be regarded as fair. Not least, of course, there must be the absence of a bias or a conflict of interest on the part of the arbitrators, which is the explanation underpinning this publication. Now, Qureshi and his assistant, Catriona, Nicol, give us what we feel is a most balanced and straightforward account on conflict, which we feel is a benefit to beginners and experienced practitioners alike. And I will add here, it's not in the review, but I would say that this is an area that I'm getting more and more clients coming to me making complaints about, saying that B's biased or there's a conflict, and quite often there's absolutely no evidence to justify it, none whatsoever. But they do say these things, and we have to look very carefully and see whether in fact there is a likelihood that the parties haven't been heard, or that someone's got too much of an interest in it, or there is a clear bias against one party. These things do happen, we're all human beings, but the point is that quite often, I'm afraid, the arguments are groundless. However, that's what the tribunals and the courts are here for. We found, of course, that the handbook also gives the reader an invaluable simple summary of the approaches now adopted by the courts in England and Wales, as well as overseas arbitration jurisdictions in countries such as France and Switzerland, which of course is very much to be welcomed. I would point out, of course, that London does tend to be very much at the heart of some of these hearings, even now, while Singapore is clearly taking some interest as well, but a lot of disputes do come to this country for resolution. So in the first part of the 21st century, the growth of the use of international arbitration has given rise to many issues, such as an increasing concern that arbitrators, quote, must be seen to be and actually be independent and impartial. Now, Bernard Ricks has written in the foreword and congratulated Wildy for the title, which he says has done us a service to practitioners and all who want to learn about this subject by collecting much of the important international material in a single volume. And that's exactly what Qureshi has done. Its purpose is a one-stop shop, and he succeeds brilliantly in his objective, in my view, and I'm sure that of other commentators. Let me conclude by saying Qureshi sets out the institutional rules applicable to challenging an arbitrator on the grounds of bias or conflict of interest, and it outlines in the book how domestic courts of each country and international arbitral tribunals have approached challenges to remove an arbitrator as events move forward at such a fast pace. I think that's important because I said before, you are getting more people questioning whether in fact there's been a conflict of interest. In other words, what we used to know as the rules of natural justice, which may well be coming back a little bit now, notwithstanding all of the possible dogma attached to some parts of the Human Rights Act. The fact is that the basic rules of natural justice are still there, and I do think that they are basic principles upon which we sort of govern our behaviour. I mean, it's really as simple as that in its jurisprudential essence. So the book is quite short, at under 200 pages, and I think you as the reader, both as a student or a practitioner, will find the case law notes listed under national laws of great assistance, together with the two annexes, which make up actually the bulk of the book. Now, the author's donated all the royalties to the Bar Benevolent Fund, and we thank him very much for doing so. I'd like to thank Wildy for publishing this book as well. The date for publication is 2016, and I've actually reviewed this at the beginning of 2017. There's the book again, one of three in the series, and then there's the back of it there. Just opening it up, you can see in the middle, this is actually one of the annexes. You can see the various rules which are covered there. And again, you've got a very large amount of detail. So you should be able to find what you might be looking for here quite easily. These are some of the cases involving national laws as well, which gives you some feel. They're well set out. You've obviously got the case referencing should you need to find them. And some of these cases are actually very important. For instance, this one is the Pinochet case, going back to the year 2000. So you can see there's a lot of substantial detail. And Qureshi himself comes from, as I've indicated before, with this and the other books, he comes to us with a very high pedigree, tremendous amount of learning and knowledge, and I'm very grateful that he's imparted it to us. So thank you very much to all concerned for another excellent title. Bye-bye.